the State Authorities Act 1987, the DLSA has constituted a High Court Legal Services Committee as well as legal services authorities at the Tisazari courts, the Magyala House courts, the Karkaduma courts, and in the Rohini courts complex. Now, the two main branches and the two main ways in which the DLSA functions is through local adalats and through legal aid. In Delhi, we have a total of 10 prisons. There are 9 central jails in Tihar and 1 district jail in Rohini. And 2 lawyers are assigned to each of the jails. And of these jails, jail number 2 and jail number 5 are the convict jails. So more senior people are sent there. The Delhi High Court Legal Services Committee has 36 panel lawyers, and the jail visiting lawyers panel comprises 25 lawyers. Now, I have some statistics which I took from the Delhi High Court Legal Services Committee, and the statistics show that in the year 2012, there were a total of 1,033 cases which were assigned by the Delhi High Court Legal Services Committee, of which 802 were criminal matters. So obviously the emphasis has really been on matters relating to crime, far more serious matters involving life and personal liberty. In the 3 months of 2013, January, February and March, the Delhi High Court Legal Services Committee has assigned a total of 199 cases, of which 131 are criminal cases. Now, as practicing lawyers, as people who see, if not trials, but at least the appeal proceedings arising from trials, what are the major loopholes, what are the major areas of concern that we find exist in implementing the very salutary provisions of legal aid? Well, I would put it down to the following. First and foremost, I think there is no effective conferencing with the person to whom legal aid is being given. Whether it is an accused, whether it is a convict, the manner in which the lawyer, whether it is the jail visiting lawyer or even worse still the appellate lawyer, the arguing counsel, the way they interact, the way the system allows us to interact with people in custody is wanting, is seriously wanting. For one, take me for example, if I receive a paper book to argue an appeal before a bench in the High Court, I really only get to read the papers. Rarely do I get to meet my client who I am representing. Rarely do I get to ask him that, look, these are the papers, do you understand them? And is there something that was amiss in your trial? It is very rare. Even if I make an effort, there is no privacy that is afforded to me during that consultation. Now this applies, and I am told, Ajay is another very eminent lawyer of the Delhi High Court Legal Services Committee, he read this out. Even the jail visiting lawyers have told us that there is absolutely no privacy and no effective consultation when we visit arrestees or prisoners in Tihar. Typically the scene that is described is that there will be 10 people altogether, 10 desks, and there will be a huge amount of noise around, and there will be 10 lawyers, and this poor man who's in custody, or maybe who's a convict, he will try to tell you something about it. Now, at the best of times, as I said, because of illiteracy and poverty and just a simple lack of understanding of what is happening to him, what is the system doing to him, what can the system do to him, by that reason alone, it is very difficult for him to be cogent, coherent, and to put his case before his counsel, his lawyer. And if this is to be done in the midst of 10 other people who are all simultaneously speaking, talking, making noise at the same time, then you can understand what kind of legal conferencing would happen in a scenario such as this. And contrast this with a case of a rich man, a man of means, who gets involved in some crime, whether intentionally or otherwise. The kind of effort, the kind when it concerns people who receive legal aid. The second major problem is of collaboration between the jail visiting lawyers and the arguing counsels. Now this is again something which I would suggest needs to be looked at systemically. A lawyer visits a person in custody. He briefs him, prepares a petition. Now the manner in which the work is really happening is that there are standard bail applications, there are standard criminal appeals, and facts are plugged in here and there, and you get a brief. And this I can say from my own experience because we almost never bother to read the appeal. The appeal as drafted. We go with the documents and the exhibits and the statements of witnesses. Why? Because the appeal is not going to say anything new. It is a standard form draft. But even then, whatever the jail visiting counsel learns, understands, gathers from his client, he never shares with me as an arguing counsel in the appellate court because I never get to meet him. Now again, contrast this with a situation where a man of means gets into trouble. He will hire maybe a law firm or maybe some very eminent counsel who will do the record work, who will do the drafting, put together the papers, and then he will go and speak to a senior counsel, sometimes more than one, to get the best advice. Now, is all this happening when it comes to legal aid? I'm afraid not. It simply doesn't happen. There is no briefing of the arguing counsel. There is no proper preparation of papers. It simply doesn't happen. The third important point that I would want to highlight is the issue of what I would describe as rigorous involvement in the whole trial process. There is no means for legal aid lawyers, jail visiting lawyers, or arguing counsel such as myself to get into independently collecting evidence or putting together material in defense of the accused. Even simple things like raising a plea of alibi. I wasn't there at the spot of the crime. Now, somebody has to help me, some relative, some family members, somebody who this man was with at that time has to come forward as a witness, as a defense witness and say that no, he wasn't there at all. We have really no means of doing that. Rarely in a criminal matter do we see any defense evidence being there. So it is just a question of disputing or creating reasonable doubt on the prosecution witnesses and on the prosecution evidence. There is really not much that is done in terms of producing defense evidence to contradict what the prosecutor is saying. Now, this again is something, it's not easy to solve. An accused without means has been given a lawyer. Now go, defend yourself. But the point is, what will the lawyer do unless he has some means of collecting evidence? And a lot of these cases that I get to see are really of people who either don't belong to Delhi at all, or they have come to Delhi for work, or they were visiting Delhi for some reason, so they come from far-flung areas of the country. So, relatives, friends, evidence, if any, is not to be found in Delhi. To go to Noida or Gurgaon or something is one thing, but to say that you please now travel to Patna and then go 200 kilometers to a smaller village next to, close to Patna and get evidence for me. Now, who does this work for the poor legal aid recipient? It's not an easy answer. Answers are not easy to find, but this is clearly something which affects the efficacy of the defense in legal aid matters. Therefore, I would say, let me cite another couple of instances. Juvenility. You will be surprised the number of cases that I have personally seen where the issue of juvenility was neither raised by the court, nor by the prosecutor, nor by the police, nor indeed by the defense. It is as if the Juvenile Justice Act exists for these gentlemen. Now, it comes to us, and fortunately Section 7A and Rule 12 of the Amended Act and Rules permits us to raise the plea at any stage. But that stage is coming 8 years later. And on a plea which would have made it an open and shut case, where the man would have been out in a matter of weeks, if not earlier, a person is spending 8 years in prison before somebody thinks, hey, were you a juvenile at the time of your arrest, at the time of your offense? And then again, to get a simple thing like a school certificate or a birth certificate or any other record to show that the person was a juvenile at the time of the offense is such a tough task. And I mean, I must confess, I give off my time quite freely for legal aid work. But if I have to do 3 legal aid matters or 4 legal aid matters in the High Court, then surely I can't be going around chasing certificates to prove that somebody is a juvenile, to prove a plea of alibi, or to prove a place of arrest or something like that. It is simply humanly impossible for me to do it. And I failed therefore in that effort. Therefore, friends, I think on the whole I would say that, at least speaking from the experience I have with the Delhi High Court Legal Services Committee, we are doing a commendable job. We are getting relief to people who earlier on were completely despondent, they had no means at all. But it's a long way off before we can say that, look, the constitutional guarantees in Article 21, 22 or 39A have today become a reality, and the justice system is equal for the rich and the poor. And all this, I think, people such as yourself, NGOs, lawyers, everybody have to come together and keep pushing so that maybe a decade later, this kind of a thing will become a reality. Thank you.